Testing procedures, tests and audits, public may refuse to release that information, particularly around auditing. They may not necessarily want staff or anybody to know how that auditing is going to happen. It's not because they don't trust them, but just that it may jeopardize the process, the integrity of that process. So they don't want to necessarily release that information. But the actual audit is releasable, right? As long as it's been finalized. So again, a balance.
There's some discretion on the part of the public body on what they choose to release. So for instance, this organization asked for a management letter sometimes that comes to the historical event. They could have actually chosen to release that event.
Oh, absolutely.
But they chose not to.
It depends. So you have to look at what's in that management letter. Right, so I can't necessarily speak to, like, I don't know what the contents were, if there was something in it, but typically what happens, so even if they chose to release or not release it, what they should do is actually take the form, or the page, redact all the parts with the appropriate sections, and then they give you that piece of paper.
Okay, so if we make one, we didn't know how to do it.
Okay.
To be honest, we didn't make that form request, but we could have gone through that process.
Yeah. Yep. So again, it's hard to sort of fit it all into one thing without actually knowing the documents. Privileged information is obviously also a public body can withhold that, so their correspondence with their lawyer, information that they've prepared for their lawyer, information that's subject to solicitor-client privilege or legal privilege, all may be withheld because that would prejudice the position of the public body. With regards to conservation of heritage sites, public bodies may withhold information that would damage or interfere with the conservation of any historical resource. I've never seen this one particularly applied because generally if you're talking about designating something as a historical resource, it's generally an exciting time for, whether it's the owner of that property or all kinds of things. So I haven't actually seen that one applied. The last discretionary exception is information that is or will be made available to the public. So if you have something that's posted if the town has something posted on its website, it does not necessarily have to release that information again. If it's available somewhere else, it can simply direct you there. But at that point, I would say they shouldn't be collecting a fee, right? Then they should be saying simply, thank you so much, Mr. John. Here is your, we see that you're looking for this report. It's available on our website. Please feel free to go and access it there. Information that's available for purchase by the public is also something that the public body doesn't have to release. So for instance, information at land titles and things that can be accessed through other means, the public body doesn't necessarily have to process those requests. But again, because the public body has a duty to assist, they should be working with the applicant to say, here's where you can go and get that information. Actually, it's going to be cheaper, it's going to be faster, this is where you're going to want to go. If you stay with us, it may take us 30 days to get you that information. We want to get it to you as quickly as we can. And then also information that will be published or released within 60 days of when an applicant has submitted their request is also something that public body may say, we know that this particular study is going to be finalized within the next couple of months, and so you know what, we're not going to take your request. It'll be up on the website within the next 30 days, and you can find it there.
In that case, will the public body be required to give you a written record of that, say an email or something?
So how my team operates is Surface Alberta has some really, really great templates. So we have actually taken those templates and just simply put our logoing on them, and that is what we use. So they have templates for responding to things of that nature. They have a whole host they actually have a whole guide on the interpretation of FOIP and yeah, all sorts of resources.
So is there an obligation of the public body to give you something that has a record to it? Because it could just say, well, they said it'd be 60 days, it's now 70 days, they haven't done it, and there's no, we never said that before.
So they should be, right? So that's part of that whole duty to assist piece, which is a really high test to meet. The public body has a duty to work with you. And if the public body is doing that correctly, they will be writing to you and saying, here's how it is, here's where you find it, and generally if they have it, here it is, like even I've never used that exception. I'd rather just give somebody it and say, you know what, I'm not going to charge you the $25 fee because it's already public information. Here you go. Right? So it's really, because this is a discretionary one, right? So it's up to the head to decide, do I want to apply that exception? Right? It's all about being open, transparent, and the time. Right? If I have something that I know I can find in 2 seconds, I'm not going to charge somebody $25 to find it. Yeah, so going back to those exceptions, I think that's the key thing, Todd, is that there's mandatory ones and then there's discretionary ones. And so the ones that are discretionary really are up to the head of the public body, whoever council appoints to be that particular individual. So for granting access, a public body can make copies of the records and send those out to the applicant once they've been reviewed, redacted, all of those sorts of things. The applicant, like I said, can come in and view the original right in the town's office. That's perfectly acceptable. Information that should be redacted should be clearly marked on the form and should have the specific section. So why that information is being withheld. So not just simply marking it, you need to help the applicant understand why. Why can't I have that piece of information? And typically it's best practice to include the sections of FOIP, so it's not even just so far as to say it's withheld under section 16. As part of my letter back, I would say it's withheld under section 16. Here's why, and here's the section. Here you go. So let's say you go through that whole process. You've asked for information, you get it back, and you're like, you know what? I don't think this is everything. I think that something's missing. I don't know what's going on here, but I'm just not comfortable with the information I got back. What an applicant can do is actually request a review of the decision of the public body, or any acts or anything that was taken by the public body to the Office of the Information and Privacy Commissioner. So what they do is they write to the Office of the Information and Privacy Commissioner and say, I'm requesting a review in accordance with the Act. And then the Privacy Commissioner takes over. They start looking at it. Is this legitimate? Can I mediate a discussion between the public body and the applicant, or is this something serious that needs to proceed to an inquiry? And that's I could talk about that in a whole nother session, where we're not going to go there tonight. Third parties who are consulted, so your businesses, your individuals that are consulted as part of releasing information, those people can also request a review from the Office of the Information and Privacy Commissioner. So let's say that a public body contacts a consultant and says, you know what, please let us know, do you think there's any harm? You write back and say, no, I do think there's harm. I don't want you releasing my unit factor. And the public body says, well, you know what, we're going to do it anyways. That person has a right to contact the Privacy Commissioner and say, you know what, I think that they violated this. This is the harm that it would cause me. And then the Privacy Commissioner sort of puts a pause on that whole thing, and the public body can't then proceed with releasing that information until that issue has been ironed out. So as I said, you ask for a review by submitting a written request. Applicants have 60 days from the decision to submit a request for review to the Office of the Information and Privacy Commissioner. I have seen the Privacy Commissioner allow for extensions beyond the 60 days. Because typically, if it's a couple of days late, the Privacy Commissioner and it's up to their discretion, but they do have the ability to provide some flexibility there. So 60 days, third parties within 30 days. So when they get that decision, I'm going to release your information, within 30 days of that, they have to contact the Privacy Commissioner if they have concerns about the information that's being released. Yep. No, he absolutely can. So what happens is that he would have how do I say this? I would have to write to Zane and say, you know what, Zane, I'm going to release this information. You have this many days to get back to me. So you write back or to contact the privacy commissioner. Typically then you go to the privacy commissioner. I have a duty before I proceed with releasing that information to Bill to actually contact the Office of the Information Privacy Commissioner and ask them, did Zane file a request for review? Like there's an actual form. So I go there, they say no, then I can release it. Right? But if I get a search back that says, yep, he's filed something, I got to stop.
So in that case, you would inform the public body that you intended to ask for a review.
Yeah, that would be my suggestion. That would be my suggestion. But there's certainly no obligation on the part of the third party. They don't have any obligation to notify. It's the public. Again, it all comes back to the public body. They have a huge amount of responsibility under this act, right? You're dealing with ratepayers. It is not an expectation that they are intimately familiar with this legislation. It's the expectation that the public body is.
But in that case, then, if it was released, the harm was done. Are there remedies specified under the act?
So that would be, so in terms of, from a public body's perspective, that all then goes to the privacy commissioner. So they would probably move into an inquiry, they may, apply fines, they can do all sorts of things, but that would be within their realm.